Hey folks, Turbine Guy coming back at you. Now, I've done a little digging lately, and I thought we would look into the continuing saga of the C Note and the legal status and where the case stands as we speak. So, for case number 27 CV 221089, the County of Hennepin versus Paul Berquist, Benjamin Field Wilson, and Superior Dreams LLC, we have as follows. First thing to note is a little bit of housekeeping in the case, and we have a notice of withdrawal of counsel, which is Christian v. Hawkins. The undersigned hereby notifies the court and the parties of the withdrawal of Christian v. Hawkins as counsel for Paul Berquist, Ben Wilson, Superior Dreams, and U.S. Boat and Recreation in the above titled action. Terrence Fleming and Jacob Harris will continue to represent Paul, Ben, and Superior Dreams and U.S. Boat. Thus, we have one lawyer out of the three that is bowing out of the case at this point. Now, on to the scheduling order and referral to mediation by Judge Moore. I have filtered some of the superfluous info out of here and just tried to pick out the most important stuff. Now, as to the parties, the joinder shall be by October 3rd if anyone else is going to join this case. October 3rd, 2022. Unrepresented parties must notify the court of that, and all corporations must be represented by legal counsel as per state statute. Discovery. Initial disclosures shall follow the statute. Expert disclosures shall follow the statute. But here's the discovery schedule. All discovery must be served in time to be completed on or before December 2nd, 2022. Discovery disputes. No discovery dispute may be brought to the attention of the court unless the parties have first conferred and made a good faith effort to solve and settle their dispute. Before a discovery motion may be filed, the parties must first engage in a telephone conference with the court to determine if the dispute can be resolved without a formal motion. And E down here, we have a discovery telephone conference scheduled for August 18th, 2022 at 8:15 a.m. to discuss the status of discovery and any issues that may have arisen by that point. Well, number 6, independent medical examinations, which need to be done by November 2nd, 2022. And all I can figure is the judge wants everybody involved in this case to go get a full psychological workup to see what's really going on. And number 7, motion deadlines. Non-dispositive motions must be heard by Non-dispositive motions must be noticed and heard by December 16, 2022, and dispositive motions must be noticed and heard by January 23, 2023. And what that means is a dispositive motion means you're disposing of the case. A non-dispositive motion means it's a motion within the case. Parties may not notice a motion for a hearing date procured by another party without express approval by the court. And now we get to the favorite things courts love to do, ADR, Alternative Dispute Resolution, better known as mediation. All mediation sessions shall be attended in person by the attorneys who will try the case, the parties involved in the litigation, claims adjusters, and any and all persons who have the authority to negotiate and settle the case. A, the counsel shall select a neutral within 30 days. So both lawyer groups have to get together and pick a mediator within 30 days. In the 4th District, parties in the court have 2 mediation pilot options for parties that qualify. This includes a pro bono or free mediation pilot program, which I'll bet you they're going to want to look into. You may be eligible for free mediation service if your annual income before taxes is less than 300% of the federal poverty guidelines. Also, the neutrals at ValueSolve ADR offer mediation services at a flat rate of $1,000 per case, $500 per party in a 2-party case, for 4th Judicial District cases up to $250,000, which this fits in the range of. Now, I tell you, I sure, Turbine Guy wishes he had this type of option previously, because these mediations can get very, very expensive and time-consuming. And lastly, ADR shall be completed by October 26, 2022, so they have to have the mediation completed by then. Mediator scheduled within a month, mediation by the end of October. Okay, both sides need to issue a joint statement of the case by March 20th, 2023. Wow, it's almost a year out. Trial, if this case is not resolved, will be tried during the trial block of May 1st, 2023. A year away from now, even. That is just crazy. Hennepin County went for an immediate injunction to get the boat moved immediately, and the trial won't happen until nearly 18 months later. Jury fee. Now, this is something new to the turbine guy. Any party seeking a jury trial must pay the required fee by January 31st, 2023. Failure to pay the required jury fee in accordance with the terms of this order may be deemed a waiver of any right to trial by jury in this action and will result in trial before the court. Get that fee paid is all I gotta say. Turbine guy trusts a good jury. Amendments. The parties must have the court's permission to amend this order. Sanctions. Failure to comply with this order may subject a party to appropriate sanctions, including the assessment of costs, exclusion of evidence, dismissal, entry of default judgment, striking of pleadings, or such other relief as a court may deem appropriate. And that court is the person who signed this order, Judge James A. Moore. Now on to what I found were the plaintiffs, Hennepin County's initial disclosures to the defendants. Please take notice, plaintiff Hennepin County makes the following initial disclosures pursuant to Minnesota statute. These disclosures are based upon the information available to plaintiff at this time, and plaintiff reserves the right to provide supplemental information should it become available. Disclosure number 1. Name and, if known, the address and telephone number of each individual likely to have discoverable information. Now, note that phrase, people, likely to have discoverable information, along with the subjects of that information that the disclosing party may use to support its claims or defenses unless the use would be solely for impeachment. On this first page, we look and we see Tony Bro, that's how you pronounce it, Hennepin County Environment and Energy Department, Lieutenant Klein, Sergeant Walden, Deputy Olson, and Hennepin County Sheriff, engineer, Michael Olmstead, permit specialist, Chief Farniak from Orono, Spring Park planner. Now, all of these, if you look on the right-hand side, basically say knowledge of the facts alleged in the complaint and relief sought. Although the top guy, general knowledge of Hennepin County boat access and corresponding relevant policies and procedures. That's just page 1 of the people Hennepin County is noticing could be called as a witness, has discoverable information, and Hennepin County may use in either their defense or their prosecution. Let's get to page 2 of that. And one more time we go down. State Patrol, Vehicle Inspector, State Patrol, Gabriel Jabor, Bart Alvarado, the Edgewater Transport guy, of course the defendants, Greg Ducat, the guy from Texas who used to own it, the insurance people, but most importantly out of this list, people, the turbine guy himself, Jay Nygaard of Orono, Minnesota, according to Hennepin County, has knowledge of the facts alleged in the complaint. So I may be called by Hennepin County at some point. Interesting. On to number 2 of disclosures. A copy or description by category and location of all documents, electronically stored information, tangible things, that they have as evidence at Hennepin County. Plaintiff is in possession of the following: reports related to the incident alleged in plaintiff's complaint, email correspondence from Minnesota State Patrol to plaintiff, statements and correspondence from defendant Paul Berkowitz to plaintiff, correspondence from Spring Park City Planner to plaintiff, and transactional and other documents involving the C-note. Investigation discovery continued. The defendant reserves the right to supplement. Number 3, a computation of each category of damages claimed by the disclosing party, who must also make available for inspection and copying under Rule 34 of the documents and So they wanted a computation, and what they got were words from Hennepin County: damage to access, storage fees, cost of installing and removing protective barriers, Hennepin County staff time and materials, which, by the way, all seems pretty self-imposed by Hennepin County. A lot of guts asking for that. But as I noted, there are no computations here, so we still really have no idea what damages Hennepin County is looking for. Number 4, for inspection and copying under Rule 34 any insurance agreement under which an insurance business may be liable to satisfy all or part possible judgment. Well, Hennepin County claims they are self-insured within limits of liability set by Minnesota statute. Employees of Hennepin County are defended and indemnified pursuant to the statute are subject to the same limits of liability discussed therein. And these disclosures are signed and submitted by Charles H. Salter in the name of Michael Freeman, Hennepin County Attorney. That's the update for today. We've got one lawyer removed himself from the case. We got the scheduling order, which pushes the trial all the way out to next May, which is 15, 18, 17 months after the initial thing was filed. And we have the disclosures of Hennepin County, in which they name a ton of people that they're going to use in their defense, including the Turbine Guy. Turbine Guy, signing off.